who are all these different people we've been talking about? There's the proposed guardian or conservator. That is the person who is saying, I want to be the guardian, I want to be the conservator. And not every petition do we know who wants to do that. Sometimes, as Judge Wolk mentioned, a petition is submitted saying this person needs a guardian. I don't want to be the guardian. I just want to let you know. And I actually, when I was serving as the court-appointed attorney for DeKalb County, a criminal defense attorney filed the petition. They had a client sitting in DeKalb County Jail who was 98 years old and completely nonverbal, but had done an act which wound him up in jail. And the criminal defense attorney is like, I don't know what to do with him. You know, he can't talk to me. And so he petitioned the court. The court found he did need a guardian. Nobody was there to be the guardian, so the county guardian became the guardian. And so now the county guardian was able to direct the defense attorney how to proceed. And they were actually able to negotiate at that point and get him into an appropriate facility. There's the proposed ward, and in this situation we're kind of assuming that's your child or your loved one. The petitioner, and I should put an S on that, petitioner or petitioners. Those are the people who are telling the court, hey, we think this person needs a guardian. Then there's the attorney that's appointed. Judge Wolk already addressed that. But there will be at least one attorney in that courtroom. And that attorney does not represent you as the petitioner. That attorney represents the proposed ward, and they have an ethical obligation to present to the court what the proposed ward wants them to present. Now, if the proposed ward can't tell the attorney what they want them to present, then lawyers' ethical rules kind of make us shift into a, you know, what's in this person's best interest. But there is a potential that Judge Wolk would appoint a guardian ad litem. And I don't know what circumstances you might consider appointing.
Here, let me first explain the difference, because this gets confused all the time. Lawyers don't understand the difference between these two. A court-appointed attorney is like, and I apologize to those of you who are not here for this situation, but who is your child's grandparents, because the court-appointed attorney does the legal equivalent of letting your kid eat cake and ice cream for dinner. They do whatever your kid wants. The guardian ad litem is like your kid's parent. They make them eat broccoli and a protein and things that they need and what's in their best interest. Attorney, anything they want. Guardian ad litem, whatever they need. Best interest. So we appoint a guardian ad litem when there is something that needs to be investigated and reported to the court to tell us what's in the best interest of this potentially protected person. We also do it when we're required to do it if, for example, there's an investment account and y'all want to continue investing in what's not authorized by the law, which is pretty conservative. If you want to sell property, if you want the authority to potentially move your child out of the state of Georgia, you can move them within Georgia without additional power, but if you want the additional power because you contemplate that you may have to move out of the state at some point and you don't want to have to come back and ask for permission to move them out of the state, anytime you ask for additional authority under the law, we appoint a guardian ad litem and they investigate. But that's what that is. But we can also investigate, we can also appoint a guardian ad litem to investigate if there's just something kind of hanky going on that just doesn't feel right, and we need somebody to let us know, because I can't take off the robe and go out and start asking questions of the social workers and people in the community.